Good morning, Ms. Miller.
SJC-10659, Commonwealth versus Smith.
Good morning, Mr. Harwell.
Good morning. May it please the Court, this case presents four separate issues, all revolving around the crime of armed home invasion. The first issue I'd like to address deals with the indictment. And the issue is this. The statute of armed home invasion, as interpreted by this Court and is also clear from the language of the statute, sets out two alternative ways of violating the statute.
Two alternative ways to violate the statute? Isn't the essence of the two ways knowledge that someone's in the home? And can't that, I mean, is that really an alternative way to violate the statute?
In a very general sense, it's the essence.
You either have
is
knowledge before you
but
come in or you gain knowledge when you're in, but knowledge is the essence.
It's two very specific and discrete scenarios.
Well, not so discrete necessarily.
What ultimately is the difference between the two? I mean, the fact is you have knowledge at the time. I mean, you have to have knowledge and have to have had it at the time that you actually enter the house.
Well, the first scenario, the easy scenario, is that when you enter and you know that someone is there, and that's relatively straightforward. The other scenario, which is the more complicated one, is that you enter without knowing that someone's there and then remain, and the remain has been interpreted by this Court to mean that for a certain appreciable time prior to committing the assault.
Yeah, but the element is knowledge, and it doesn't really matter when you acquire that knowledge. Why does it matter? The public policy is get you out of the house when there's a homeowner or a person in it. So why does it matter when you acquire the knowledge?
In a sense, it matters when you acquire the knowledge because that's what the statute says. And in the sense, this
No, it says either way.
This
Basically, either way, whether you acquire it before you go in or whether you acquire it while you're in, either way, you've committed the crime. So there's no real difference.
Well, in some circumstances, I mean, what the Court in Ruiz was doing, in part, was distinguishing this from armed assault in a dwelling, because it recognized that when you assault someone, you know they're there.
But
It was
Ruiz
dealing with a different problem.
it was addressed to sufficiency of the evidence. That was, I don't think it has anything to do with when he becomes armed, but it has to do with his knowledge when he enters.
I agree. Ruiz is a different question,
Yeah.
but it's basically to get the answer to the Ruiz question, the Court had to set out how to interpret the statute. And one of its goals was to differentiate this statute from armed assault in a dwelling. And so it imposed, as to this second alternative, it imposed this appreciable time requirement, so that merely attacking someone when you see them is not enough to constitute the crime of armed
So what's the problem in this case? What's the problem with the evidence in this case? He knew someone was in the home. He tried to get in. They forced him back. He tried to get in again. I mean, so what's at issue here? When it comes with respect to this knowledge, whether he had knowledge before or had gained knowledge as soon as there was resistance and he continued to fight to try to get in, what's the importance here?
Well, the importance, in a way, the importance isn't really maybe in terms of thinking of the outcome of this. Did this person commit a crime? The importance is I would see in a different way, in that did this person commit the crime that they've been charged with? Did this person actually, did the grand jury return an indictment that charged the crime that covers what the allegations were?
Mr. Harwell, you don't really dispute that the defendant had knowledge there was someone in there. You're saying they didn't use the proper charge. They did, isn't that it?
Yes.
That's right.
He
knew somebody was there, but the Commonwealth didn't charge him properly.
If the Commonwealth had charged him with entering with knowledge, I think this would be this argument would not be feasible.
You're saying there's insufficient evidence for that aspect of the statute that was quoted verbatim in the indictment.
That's right. So there wouldn't be a sufficiency problem with respect to the part that was not quoted in the indictment.
So there's insufficient evidence that he didn't know? Insufficient evidence that he didn't know before he entered that there was someone there. Is that what you're saying?
No, the other way. Correct?
The evidence was that he did know when he entered. And so I think what you're saying is right. Basically, the case law says that the second alternative, the one that was actually charged...
You have to
indictment-
prove that he didn't know. Isn't that very awkward and fairly counterintuitive? You have to prove he didn't know. If he knew he committed the crime, if he knew before he committed the crime, and if he knows after he committed the crime, and you're saying because of this alternative, the Commonwealth actually has to prove that he didn't know there was someone in the building when he broke in?
Isn't that form over substance to a fare-thee-well?
I am not contending that that is an obviously right result in theory. I mean, it is obviously a little counterintuitive.
Well,
That's what the case law says.
is it a defense to the crime to know beforehand? If you're charged with as this man was charged, but in fact you know in advance that the person is there, not you don't acquire the knowledge after entry takes place. Is it a defense to the crime, an absolute defense that you knew in advance?
Well, the weird thing about this case is that if you know...
No, is it a defense?
Our position is that would be a defense to an indictment that charges only the second alternative under the statute. It would be essentially an admission of guilt as to the first alternative under the statute.
So you're saying there's a variance between the indictment and the evidence?
I'm saying that on the indictment as drawn, the evidence was not sufficient. The other thing that I did want to say on the sufficiency issue with respect to the second alternative is that the law is clear that there has to be what's called an appreciable time prior to the assault, that the knowledge is gained an appreciable time prior to the assault.
In the dwelling.
After the entry. So the
In the
person
dwelling.
goes in, learns that someone is there, an appreciable time passes, then the assault occurs. Here the facts are very clear that the assault and that there was no appreciable time, that the assault happened at the exact same time that any entry occurred.
If I could give you a hypo, I'm sorry.
What is the prejudice to the defendant here?
The prejudice is he has a constitutional right to be convicted only on an indictment that's returned by a grand jury. And here, although the grand jury did return an indictment, it wasn't for the crime that the court instructed the jury on. I mean, the defendant had every right to show up at trial, sit through trial, and expect to get a required finding because the evidence was not sufficient to prove what the indictment said. And instead, at the end of the case, the judge instructed on an entirely on an offense that was not set out in the indictment, and suddenly the jury could return a verdict.
So you're saying the statute has sort of describes two separate offenses?
It's two different scienter elements, isn't it?
That's right. And I don't know what the right word to choose, whether it's theories or ways or methods or means.
I take it, Mr. Harwell, that presumably one could have an indictment that didn't quote from the statute but essentially covered both elements. That would be okay. And I take it your argument is no, they relied solely on that prong of the statute that says you come in not knowing somebody's in there and you have to be there for an appreciable period of time before you assault somebody.
And that's right. And I've tried to. I made a little chart in my brief trying to show that this is exactly the language of half of the statute. And the Commonwealth has a theory for how half the language means all the language, but it's so counterintuitive to think that the prosecutor or the grand jury would coincidentally choose exactly verbatim half the language of the statute when it was intending to charge.
But I've got two questions. One is there any reason to think that the jury indicted him on a theory which plainly was not the evidence before the grand jury? That is, that he entered and at an appreciable time later learned that somebody was inside? Are we really worried about that?
I'm not sure I understand that.
Well, I mean, is there any real reason to believe that the grand jury indicted on the theory which you allege is stated in the indictment? Is there any real reason to think that the grand jury indicted on one theory and the petty jury convicted on another?
I mean, I don't know what was in the head of the grand jury. All we have from the grand jury is the indictment, which to me seems fairly clear that they were charging the second alternative.
All right. Well, let me give you a hypo. Imagine a different case in which both theories are charged, and imagine that there is a dispute in the evidence as to whether or not the defendant entered with knowledge of somebody being present, or learned of the presence of that person after he was inside? Let's assume that 6 jurors believe he knew before, 6 jurors believe he knew after. Hung jury or a conviction?
I would say 2 things. First of all, I think my position is that would be a hung jury. And I recognize that's counterintuitive, but that's what the case law says in describing the 2 alternatives. The second thing I would say is that even if the court doesn't buy my argument that the absence of knowledge is either an element or an absolute defense to the second alternative, that even if the court rejects that part of my argument, there's still the appreciable time requirement issue.
Mr. Harwell, let me just elaborate on Justice Gantz's hypothetical. Let's assume that you have an indictment that is the same as the indictment in this case, namely a quotation from the statute that goes to the second or a second scienter element. And the judge instructs the jury on only that element, and 6 members of the jury think that actually he knew before he came in, but that he assaulted the person as soon as he came in. And 6 people say, no, he was in there for quite a long time before he assaulted. Hung jury?
I think so in that scenario, yes.
So what you're saying is, I take it, is, and again, I'm just summarizing your argument, he knows what the indictment charges, and he prepares a defense on the basis of that indictment. And then the judge instructs in a manner that is different from the indictment.
That's right. I mean, a defendant has every right to read an indictment, to look at the statute, to read the case law, to know what it charges, and to show up. And this defendant could have even just sat there and not said anything, and be entitled at the end of the case to required finding him not guilty.
So that was his defense.
What do we do with the fact that, in fact, if we had the minutes of the grand jury and the testimony before the grand jury from whichever witness the Commonwealth chooses to present to the grand jury says, co-conspirator, somebody, I don't know whether he knew there was anybody who was in there, but we went in and we went upstairs and then we went down to the basement and we discovered him in the basement, and that's when the assault took place. Fine. Grand jury returns this indictment. Appreciable period of time in the house. And then there's another Commonwealth witness that testifies at trial, the one who testified before the grand jury, having disappeared. He says, oh, no, I spoke to the defendant, and he said, I know X is in the basement. Your argument is, the defendant doesn't have to put on defense at that time, correct? In other words, if the evidence is different, the indictment in fact mirrors what was presented to the grand jury, but it just so happens that the evidence of trial was that the defendant knew, or the jury could conclude that the defendant knew, and your argument is that shouldn't even be admissible, I take it.
I guess I'm not pushing this court to open an inquiry into what was before the grand jury.
No, I understand that, but I'm just assuming that we had the minutes of the grand jury, and we know what was presented.
And I'm thinking there are certainly some limitations on the extent to which a prosecution can proceed on different evidence at trial than is presented to the grand jury. But,
sure.
Essentially what we have is the work of the grand jury. What we have is the indictment. And if we're not going to completely get rid of the indictment requirement, I think we have to take that at face value, that the language is chosen for a reason and is intended to charge the offense that the grand jury...
It's chosen for a reason to make sure that all the alternatives are covered, not to sort of give someone an out because, gosh, I knew before I went, as opposed to I found out when I went.
The way you cover all the alternatives is writing out all the alternatives. That's what's so strange about this case. It is very, very easy for the grand jury to have returned an indictment that would have covered both alternatives.
And tell me what your prejudice is. This variance you claim, what is your prejudice?
He defended on the basis that he wasn't with the other guy, that he wasn't a joint venture with the other fellow.
And there were other charges also. So there were trial defenses that didn't relate to this charge. But my position is when you have a constructive amendment where the court instructs the jury on a broader basis than is in the indictment as returned by the grand jury, that is the prejudice, is the denial of the Article 12 right to an indictment by a grand jury. There's no requirement of any prejudice showing that a trial defense would have been different. The appeals court has a recent decision called Williams that I think is very persuasive on this. It doesn't matter how the trial was presented. It doesn't matter what the defendant thought was going to be the trial was going to be about. If you have a constructive amendment, that's fatal.
But isn't there some merit to I take it, the Commonwealth's position that actually the first alternative, as you put it, is a subset of the second? I mean, if you just look at the language, logic would say that knowingly entering a dwelling place, knowing or having reason to know that one or more persons is present within, is a subset of knowingly entering and remaining in place when you have reason to know.
I don't think that's right, because the first alternative doesn't have a remains issue. You know when you go in. The second alternative, you don't have to know when you go in, but you have a remains alternative. So it's discrete elements.
Well, at the time of the assault seems to me to be the critical time. And that's when you either knew before or you knew for an appreciable time. So you knew. And that's what has to be proved.
You either knew when you came in or you knew for an appreciable time.
Right. And so
That's
by
correct.
the time of the assault, you've got that knowledge deep in you.
And I mean,
And so
like I said, to a certain generality, it's just knowledge. But this is very specific kinds of knowledge. And this isn't that the statute says knowledge, and the courts have come up with different ways of defining knowledge. These are two alternatives that are specifically set out in the statute, and I would argue are set out in the statute for a reason. If there's no further questions, I'll rest on my briefs.
Thank you, Mr. Harwell. Good morning, Mr. Ditkoff.
Good morning, Your Honor. May it please the Court, Joseph Ditkoff for the Commonwealth. With me is Corey Flashner. He was the trial prosecutor in this case. He's not with my office anymore, but he has graciously donated his time this morning to assist me. Your Honor, first just jumping to the grand jury minutes before I get into my argument. They were before the lower court in the McCarthy motion on the firearms, so they would be a legitimate part of this record, and I'd be very happy to submit them to the court if the court would like them. They're pretty similar to the trial evidence. Seeing no strong feeling either way.
If I could turn your attention to the argument that has not been discussed, which is whether entry with a weapon is sufficient. Is it your position that if it turns out that it is not sufficient, that the conviction may still stand because it's harmless error, or is your view that we need to find that the entry with a weapon is the appropriate instruction?
It is my position that it would be harmless error if that were error. My primary position, of course, is that that wasn't error. That is the proper law.
Excuse me, Mr. Ditkoff, could you just repeat that? I lost.
I'm sorry, Your Honor. My position is that it would be harmless error if that was erroneous because the evidence of an actual physical entry is so strong here in this case, really uncontested. What was really contested was whether the defendant and the masked gunman
I thought
were
Justice
in league.
Gantz's question, is entry with a weapon sufficient?
I certainly think it's sufficient, but I think he also wanted to know whether, if he disagreed with that, whether I agreed the case had to be reversed or whether I thought it was harmless. And I think it is sufficient, but if it is not...
Let's assume that it's not sufficient. That's where I'm losing you.
Right, then I believe the error is harmless. But my primary argument is that it is sufficient.
And it's harmless because?
It's harmless because here the evidence that there was a physical entry with the body was uncontested, was very solid. We had, in fact, the way it was argued in closing argument, the prosecutor, the first thing he says about entry is his foot in the door. That's the entry. Brian Smith puts his foot in the door as the victim starts to close the door, and he's pushing, he and the masked gunman are pushing against the door for a considerable amount of time up until the gun is finally fired into the apartment. And no one really argues that the door is being pushed in. Attorney Sheketoff does argue that Brian Smith's foot may be an exaggeration by the victim. But that, and the door opens inward. You can see that in my appendix. I put the picture of the door. It's pretty, in the transcript. It's in there in the transcript as well. And so there really isn't any question that someone has crossed the threshold of the door, and they were instructed that the threshold is where the door is when it's closed, which under Stokes is the correct entry. And so there was an entry by the body as well as by the gun. So I do think it's harmless. But my primary argument is that is correct. We look at the common law meaning of the term, which has always been including an instrument that was used not for breaking, but used for either the felony inside, which in this case would be the threatening force, or the parallel be threatening force or causing injury. And that should be the weapon, which is what the appeals court concluded in Werner on 18A.
Okay, so help me with that if you would. It's my understanding from your brief that if a burglarious tool, which was not a weapon, had been the only thing which had entered, that he was carrying a weapon outside the door, but the only thing that had entered the apartment was a burglarious tool to open the door, and then he was caught outside, that he would not then be guilty of home invasion. Is that your position?
Yes,
So it has to be an actual weapon to enter, not merely a wedge or something else to open the door.
that is my position. I mean, if I could go back and change common law, I think it would make sense that anything you're holding count as an entry. But that is not how the common law developed, not at all, or how this court developed the common law. They've always rejected an instrument that was used for the breaking as counting as an entry, I guess, so that the crowbar on the window to break the window doesn't also fill the element of entering. So the parallels, it has to be an instrument that's not being used to do the break, and that's always how the common law has been. And this court has said that we start with terms that are common law terms, and we interpret them in common law, and that's how this court decided that the entry has to be an unlawful entry. There's no word unlawful in the statute, but the legislature is presumed, when they used entry in the statute, to mean entry in the common law sense, which has always meant an unlawful entry, not just anyone who enters. So if you open a door and walk in with the intent to commit felony, you're a burglar. That's, if you're invited, that's never been how the law worked.
Mr. Ditkoff, help me if you can. Going back to the indictment, I'm looking at the appeals court decision at page 199. The indictment, the appeals court said, did not include one of the scienter elements. Rather, and this is the piece that I don't quite understand, it can be read as having merged the two into one without affecting what the Commonwealth needed to prove. If it only recites one verbatim from the statute, how can we read that to have merged the two elements?
Well, I mean, I don't agree with the appeals court opinion on that point. If you look at the indictment giving us all the ands and ors interchangeably, as we're allowed to do, then we have alleged both of them. But I really think in this issue, my brother has zeroed in on the key issue, which is the question of whether absence of knowledge can ever be an element of armed home invasion. Because if my brother's correct that it is, there are two mutually exclusive crimes, different crimes that happen to share the same section number, 18C, and you can't commit them both. You either commit one or you commit the other. You either have knowledge when you enter, or it's proved beyond a reasonable doubt you didn't have knowledge. And if that's true, then his claim that he was indicted, that he stands convicted of a crime for which he was not indicted, has some plausibility depending on how you read the indictment. But if the Commonwealth's view is correct, that is not the case, that there is one scienter, which is knowledge of occupation, that can be proved either at the moment of entry or any appreciable time before the final assault, and usually is proved in both ways, and they're not separate crimes, then at worst the indictment is inartfully drafted, but he is certainly stands convicted of the crime for which he was indicted. And then the only question is, one, is the indictment inartfully drafted? And I don't agree that it is. But if it is, did that inartful drafting prejudice the defendant in any way? And there really isn't any claim that he was actually prejudiced. Attorney Sheketoff himself says, my defense was that he was there but a non-participant. There was no argument from Attorney Sheketoff about when he gained knowledge or anything like this. That was the defense. It was a good defense on the facts of this case. The jury rejected it, but that was the defense. In no way, Attorney Sheketoff didn't even realize that he had an argument about the indictment language until well into the case, until after the evidence. So there's no defense there.
So
Well,
explain to me how. Go ahead, Chief.
I was going to say, presumably, because he looks at the indictment and he figures out that the evidence is going to show that this man didn't have the knowledge beforehand, leaving aside who led the grand jury minutes, that he was in the apartment for an appreciable period of time as the case laws developed, with the victim standing right there, correct?
Yes, Your Honor.
So that, and if that's the case, doesn't that resolve the problem? Whatever the problem is, if the evidence supports a conviction that there was an appreciable period of time when the defendant was in the house knowing that the person was there, once the defendant is in the house, end of case, right?
I believe so, Your Honor.
And you're telling me that's what the evidence will show if we look at the record.
Yes, Your Honor.
I'm sorry. If the indictment if the circumstances of this case had been sort of the converse, if the indictment had alleged the first statutory alternative, that he had knowledge before he went in, and in fact the evidence showed that no, he did not have any knowledge before he went in, but he acquired knowledge after he went in, and he acquired that knowledge appreciably before the assault occurred, would the result still be the same?
I believe so, Your Honor. It would obviously be a much tougher case. But
Why?
Because
I mean, why in the sense that if you really talk about having the two or really the one, why would it be a tougher case?
maybe it wouldn't, Your Honor. But my point was that Chapter 277, Section 34 says an indictment shall not be considered defective or insufficient if it is sufficient to enable a defendant to understand the charge and prepare his defense. And even if an element, a scienter element, is actually left out, like in Pecul or Green or Bacon, that's not fatal to the charge as long as the defendant isn't prejudiced, he understands the charge, and he is able to prepare his defense. And in that situation, it would depend on what the discovery was, but in that situation, I think it would still be okay. It wouldn't be something to be proud of.
Explain this to me. We have other criminal statutes that charge a crime, larceny or burglarious instruments, possession of burglarious instruments. The Colorado case, Commonwealth versus Colorado, was burglarious instruments, and I think it's Commonwealth versus Mills is larceny. But within those statutes, there's lots of different ways to commit larceny. You can charge just larceny, and then I assume establish it in one of different ways. But if you select one of those ways, at least that's what Mills tells us, then, and your proof varies, then you're in trouble. How is this different?
Well, my understanding is I'm not really familiar with Mills, I'm afraid, Your Honor.
You want to talk about Colorado then? That's the burglarious instruments, where they charge burglarious instruments and they prove master keys. Master keys is also included in the burglarious instruments.
I'm afraid I'm not familiar with that case as well, Your Honor. I'm sorry. But there are a few answers to that. I mean, one, there are certainly cases where a particular way was picked, like in Jones, where it was a putting in fear armed robbery, and it was submitted on actual force, and that wasn't considered a problem. But more importantly, that presumes, going back to where we started, that there are two separate crimes. The various theories of larceny have completely different elements, and they are different crimes.
But
and
here the
again,
statute sets out these different elements. I mean, I think you and I could probably agree that we could redraft the statute so that it didn't set out two separate scienter elements, correct? We could probably, in the appeals court language, merge them in some kind of way.
surely, Your Honor.
Yeah.
But when you have a crime like larceny, where there are different ways of proving it with completely different elements, that's very different than, at least, that's what my brother is claiming this crime is. There are two different ways of proving it that are mutually exclusive with completely different elements. But if I'm correct that ignorance of occupation is not an element, and this is just one thing of proving that one thing that's proved, which is knowledge of occupation, and can be proved at two different times, either at entry or an appreciable period before the final assault, then it isn't like that, where the theories of larceny are quite distinct. It's really one crime that's proved both ways, and it isn't really parallel to a larceny situation or even a first-degree murder situation, where the three theories of first-degree murder are very different, yet only last week this court found once again that the statutory form, assault and beat, is adequate to allege all the theories
Mr.
of
Ditkov,
first-degree murder.
forgive me for this. Do we know where the or entered without knowledge language comes from?
Well, it first appears in the Ruiz case. It's repeated several times, in many cases, even the decision below. And was this court's way of describing the two theories to try to explain its interpretation of when one has to have knowledge of entry. But it's a classic example of how you can't just take language in an opinion and think that a description of something is something that can be given to the jury as an instruction. Just because the court is talking about how a statutory scheme works doesn't mean that is what the instructions are. And no court, this court or the appeals court, has ever held that ignorance of occupation at the moment of entry is an element that should be instructed to the jury. In fact, in Brown, the John Brown case, which was 451, the 451 Mass Brown case, this court approved the MCLE model instructions, which don't require the jury to find ignorance of occupation. And Attorney Sheketoff in this case didn't ask that that be instructed. I'm not aware of any case where that's been instructed. But that's where it comes from the description of the case. And I don't think it's an unfair description, because normally, I mean, as here,
Well, I'm looking back to the statute, because the statute does have this or, and I assume that really is a reflection of the statute.
It certainly says or. They are disjunctive in the statute, which doesn't mean they have to be disjunctive in the indictment language. If there are no further questions.
Thank you, Mr. Ditkov.
Thank you, Your Honors. Would the court like the grand jury minutes?
If you would like to submit them, that would be fine.
Okay, thank you, Your Honors.
Defendant has no objection.